Good morning. Welcome to the 9th webinar for healthcare professionals concerning the work that we do and how it relates to the insurance legislation that we all work with. I'd like to welcome, first of all, the Thomson Rogers firm to this webinar. The webinars, this is the 9th, were started quite some time ago by McLeish Orlando and my firm, Oatley Vigmund. They are now and hereafter webinars of the Personal Injury Alliance, with Thomson Rogers being the third firm in that alliance. I'd like to introduce your panelists to you before we get started. On my left is Michelle Bauman. Michelle is one of our accident benefits specialists, spending all of her time working within the accident benefit system on behalf of our clients. To Michelle's left is Anne Marie Musson. Anne is a defense lawyer who does nothing but accident benefits work, and she tells me that she loves every minute of it. Anne-Marie is with the Miller-Thompson firm and brings a great deal of defense experience and perspective to the issues that we're going to discuss with you this morning. On her left is Vanessa Femia. Just like Michelle in our firm, Vanessa is an accident benefits clerk at McLeish Orlando, spending all of her time working with the accident benefit system for McLeish Orlando's clients. Sitting in front of Vanessa is Wanda Rumson. Wanda is described at Allstate as a rehab service advisor, and Michelle tells me that she's better known as an adjuster extraordinaire. We all know Wanda because she deals just about exclusively with catastrophic claims and brings years of experience to our discussion today. To Wanda's right is Pat Brown. Pat is a partner at McLeish Orlando. Pat does both tort and accident benefits work on behalf of plaintiffs. To Pat's right is Barbara O'Gorman. Barb is a senior law clerk with Thomson Rogers, and like Vanessa and like Michelle, her work is entirely on behalf of their clients within the accident benefit system. And to Barb's right, our final panelist is Darcy McCurr from Thomson Rogers. Like Pat, does work both with respect to the accident benefit system and the tort system. And once again, a special welcome to Barb and Darcy representing the Thomson Rogers firm for the first time. I'm Roger Oatley. I'm a partner at Oatley Vigmund. I'm your moderator for the webinar today. As of just a few days ago now, we are contemplating the possibility of drastic changes to the accident benefit system, changes that none of us expected, none of us knew about. The amount of consultation with the healthcare industry, if I may call it that, and the legal profession was exactly zero. So if you're wondering where it came from, none of us on this panel have any idea, other than perhaps the pressure imposed on the system by the unfortunate demand of the NDP some time ago now that the government reduce premiums by 15%. We are living with the consequences of that demand. Now, before I ask Darcy to review those changes for you, and before we discuss some of the implications, I'll just take a moment to put this into some historical perspective. Many of us on this panel have been around long enough to remember the introduction of the first so-called no-fault system in 1990 by the then Peterson Liberal government. That government introduced the so-called threshold system in tort and introduced accident benefits which provided for $500,000 of med rehab funding and $500,000 of attendant care funding. The big difference between that and what's proposed today is that those limits were available to everybody. There was no separate category for the majority of people and another category for those who were catastrophically impaired. That system lasted for a while, and then the people of Ontario replaced the Liberal government of that day with the new Democratic Party government. That party introduced another drastic change to the system, virtually eliminating the tort system with the exception of claims for non-pecuniary loss, also known as damages for pain and suffering to most people. And the NDP government introduced an elaborate, highly expensive system of no-fault benefits or accident benefits that cost the insurance industry a huge amount of money. The insurance industry was anxious to see the end of that legislation and, in fact, approached the legal profession and worked with some of us to come up with jointly supported recommendations for the government about yet another new system. The next new system was introduced by the Conservative government. Again, there were very drastic changes to accident benefits, significant expansion of tort rights again, back to a system that we related to historically much more easily. And I've had a standard joke over the years when I'm speaking about our insurance system, and that is that as soon as I'm starting to understand the system, I get worried because then I know it's about to change. Well, I was just getting to understand this system, and I think we all were, and the courts were, and the adjusters were, and we were all working with it fairly well, and suddenly this bombshell. I think we're all, it's safe to say, in a state of shock and all worried about what these changes will do to our clients who fall under this new system if it becomes law. So Darcy, why don't you start us off, please, and give us an overview of what the new system is going to look like if it does indeed come to fruition.
Thank you, Roger. There are 5 primary changes that have been announced. And the key point is that all of them, without exception, without question, have negative impacts on the rights of accident victims and their recovery. And it causes great concern to those of us, healthcare professionals, lawyers, insurance adjusters, who try to help people recover following an accident. I'm going to deal with the 5 changes that are proposed, that were announced by the government in a hierarchy from the least significant change. Again, it's a negative change. It's not one that's good at all for accident victims, but then leading to the more serious ones. The first one is for non-catastrophic claims. So currently for non-catastrophic claims, those are mild brain injury cases, fracture cases, orthopedic cases that are more serious than the minor injury guideline cases, but not as serious, at least at present, as catastrophic impairment claims. Currently, there's a $50,000 cap for medical and rehabilitation benefits, plus access to $36,000 in attendant care, totaling $86,000. The announcement reduces that $86,000 total to $65,000 and says that the two benefit provisions go together to max out at $65,000, putting some tension on which funds to access, whether to access the attendant care and med rehab. They've also, related to that, reduced the duration for which that can be accessed from 10 years to 5 years, except in the case of children, which continues to have a longer period. The second change deals with non-earner benefits. Non-earner benefits are benefits, it's a weekly benefit available to primarily people who weren't working at the time of the accident, children, students, elderly, stay-at-home parents. And currently, it was payable after a 6-month waiting period, $185 per week, and then had the potential to increase to $320 per week in cases of people for students primarily. They've now, according to the government announcement, they're going to eliminate the waiting period eliminate the 6-month waiting period altogether, and eliminate the duration and limit it to 2 years. So currently it was available for life, or at least until age 65, and then ramp down thereafter. And the proposal is to access that benefit only for 2 years, meaning that students can have access to the reduced rate for 2 years, and then they're off that payroll. The third change deals with tort rights. Tort rights are claims against at-fault drivers, and currently there's a threshold, there's a deductible of $30,000 that applies on cases where the pain and suffering awards are worth $100,000 or less. The government has announced that they're going to index that amount to inflation since 2003, which would increase that $30,000 deductible to something in the neighborhood of $37,000. With respect to the vanishing deductible, meaning that for cases that are currently assessed at more than $100,000 for pain and suffering, the deductible does not apply, but that vanishing deductible would also be indexed to inflation to increase that to over $120,000 or close to $125,000. So again, negative changes which will allow more claimants to be faced with the deductible, therefore reducing their recovery in the lawsuits. The last two are the most important to the people involved in this panel and the people watching. The catastrophic limit. Currently, you can access $1 million in medical benefits plus $1 million in attendant care benefits for a $2 million maximum, as well as some other benefits. The government has announced that that $2 million total is going to be reduced to $1 million, halved, and that the two benefit policies will be dealt with together in terms of the limits so that you can't access it over $1 million regardless of which pot it comes from. So that is the one that's causing the most attention, causing the most concern, because in those extremely serious catastrophic impairment cases, you clearly need more than the $1 million in each of those benefits, never mind $1 million in total. The last one, which has only been referenced in the government announcement, deals with the catastrophic definition. And what they've alluded to is that they're going to go back and revisit the proposed changes from a few years back and adopt a new catastrophic definition that's more scientific based, which essentially means the elimination of the GCS test, which was what was proposed a few years ago and surely will be back on the table. So right now we don't have a reason to be overly concerned with the actual definition, because the actual definition has not been presented. But the expectation is the catastrophic definition will be narrowed significantly, resulting in less people accessing the now reduced $1 million limits. Roger.
Thanks, Darcy. I'd like to ask the senior insurance adjuster on our panel, Wanda Runsum, who has years of experience dealing with catastrophic claims. What implications do you see this having? What impact do you see it's going to have, Wanda, on profoundly impaired people who are under the definition of catastrophic impairment?
It's going to have a significant impact, and especially in the individuals who are young and spinal cord injuries and serious head injuries. At this time, for those individuals, the combined $2 million is not sufficient to meet their medical and rehabilitation needs for their lifetime. So I can't imagine how $1 million combined is going to come close to meeting the needs. For example, a person with a spinal cord injury, today the average cost of home renovations we're looking at is $350,000. A modified vehicle for a spinal cord injury is $72,000. So put the numbers together, and there's at least half their limits just on those two essential items.
What changes, if this does come into law, what changes do you see coming, Wanda, in relation to how those claims are going to be adjusted, if any?
Good question, Roger. This is just rolled out, and we haven't had time to give it a lot of thought. But I would assume, as an adjuster, being aware that my client's limits are reduced to half, that we may have more discussions with the treatment providers into let's get back to more essentials. What does the client really need, not what would be best to improve his functions or reintegrate him, but what are more his essential needs, and so that we can preserve this person's limits for a longer period of time.
Thanks, Wanda. Let me ask you, Anne-Marie, from your perspective as a defense lawyer, I know that your objective in handling one of these catastrophic injury disputes is fairness. Fairness not just for the company who you represent, but also for the insured. What do you anticipate will be the impact on the way you will defend these cases and approach eventually the cashing out of settlements once it's known what the lifetime needs of these catastrophically impaired people are going to be?
Well, I think it follows a little bit with what Wanda said, and I think we can expect there's going to be a significant amount of extra scrutiny on these claims in terms of how the dollars are being spent, in terms of how the treatment plans are being either approved or denied, and whether assessments are going to be arranged, etc. So I think from a defense perspective, we can anticipate there will be a lot more investigations into how the dollars are being spent. And in terms of how we would go about cashing out these claims, I mean, the bottom line is it probably makes it a little bit easier, quite frankly, because there's less money on the table. And as Wanda indicated, a few reasonable, significant treatment plans with respect to home modifications, with respect to if we have a Form 1 on the file that indicates $6,000 a month attendant care, it seems to me that these claims are probably going to be much easier to resolve because the money is just not there.
I'd like to, before we leave this, ask both Wanda and Anne-Marie in whichever order you prefer. If the benefit is reduced from $1 million for med rehab and $1 million to attendant for attendant care down to $500 for each, in other words, cut in half, from what you see in the work that you do, how adequate is that benefit going to be? How quickly will those monies get used up?
Well, I'll address this one. I see it's going to have a significant impact because with, again, as I outlined earlier, the spinal cord injury, typically once they're released from Lyndhurst, the monies are expended up front, the homes, the vehicles, and then we start with the physical therapy, occupational therapy, whatnot. So there's not going to be much in the limits left for any burn rate. When we're looking at serious head injuries, medically we're told the first 18 months to 2 years is the period the individual should be receiving front-loaded rehab because that's their period of their recovery. So again, like RSWs, the cost of that, and all the rehabilitation, the first 2 years is a high burn rate. So again, we're not going to have a lot of monies left for the duration of their life. Roger, to address the question you asked earlier about cash outs, at this time, I agree that it's probably likely much easier, and also it would likely be much more in the client's interest if we were to cash the claim out, because put in a structure, it enable them to receive monies for a longer duration.
That's an interesting point. Anne-Marie?
I agree with what Wanda is saying, but I do think that we do have a segment of catastrophically impaired people who do actually have a pretty good recovery, and not all of them necessarily needed the full $2 million. Sometimes I've had cases where claimants actually initially had some front-loaded treatment, and then while they've been rehabilitated have actually been able to go on and be quite successful in terms of careers, etc. So there are a percentage of people that this might not affect as much, but I do tend to agree with Wanda. That's not most of the people that we're dealing with. The files that we have now, where the limits are $2 million, in many cases that's not even enough. So unfortunately, with the reduction in half, where most of the claims probably are going to be affected.
I can say before I ask the next question that one of the concerns that we plaintiffs' lawyers have is that third-party limits just don't seem to be increasing under people's policies. It's been $1 million now for quite some time, and when we sit down with a catastrophically impaired person who's got a lifetime of needs and explain to them now that there's $1 million available in tort and potentially 1 million med rehab and 1 million attendant care, families start to cry in despair because they realize over a lifetime that that's not close to meeting the needs of the person they love and care about. And I can't imagine what it's going to be like telling people that those benefits have been cut in half. Let me ask a question about another aspect of these changes, and that's with respect to the further reduction to the non-cat limits, because this is the second time in a very short period that we've seen these limits eroded. Michelle, you work, I know, in our office with seriously injured people. Not all of them fit the catastrophic impairment definition. How quickly and how frequently do the benefits available in the non-cat cases get used up?
Mm-hmm. Certainly that's a case-by-case question. But I would say it's with fair frequency, and quite sadly, that we see people exhausting their current $86,000 of medical and attendant care benefits. People are often exhausting those benefits within 6 months to a year of their accident. So in the case where we're having to wait for the 2-year anniversary of a car accident to apply on a whole person impairment or a marked impairment for catastrophic determination, we are out of money for quite a long period of time. I can only imagine with this further reduction to $65,000 for medical rehab and for attendant care, that there's probably going to be two impacts. The first impact, of course, is that we'll see the limits exhausted that much more quickly. But the second impact that I speculate we may see is that we may see our clients resisting rehabilitation for fear of using up all of the money. And this is something that we already see with our clients, be them non-catastrophic or catastrophically impaired. But as you say, Roger, when we sit down in that initial meeting and we explain to them the money that's available, I can foresee that people may start to think, oh, no, maybe I don't need that occupational therapy. Maybe I don't need that speech therapy. I better hang on to it for a rainy day. And then expanding on Wanda, you end up seeing people who perhaps don't have the full access to the rehab in the acute days when they could make the most significant recovery and gain. So on the whole, I think this is a very scary change.
And just before we leave this topic, Barb or Vanessa, is your experience the same with the non-cat cases? Will this further erosion of the benefits available to non-catastrophically injured people have an impact?
Yes, Roger, it definitely will.
And Vanessa?
I agree as well.
Yeah.
Can I just make one point on that, Roger? A lot of our cases that we've been dealing with, A lot of the individuals don't actually meet the definition of incurred with respect to attendant care benefits. So I actually see this change of combining the limits maybe not necessarily a bad thing in certain circumstances. I appreciate the fact that in some cases the limits are exhausted on both the attendant care and the med rehab, but the fact of the matter is now there may in fact be some additional money available for rehabilitation where they weren't actually qualifying for the attendant care benefit because of the definition of incurred.
Well, that's a great point. You're saying that there's potentially $65,000 of med rehab money, which is an increase from 50.
Right.
Well, that's great to have a positive spin on something for you today.
I appreciate the
contrast, though, to that, which is that now you're tapping in. So there was just a discussion about eroding policies too quickly and accessing the OT or physio. Now you're going to be balancing that with your need to have supervision. Mm-hmm. So the supervision is going to impact your ability to access the physio and the OT and the therapies that are recommended that you may not have money for. So that poses a very challenging balance between how much supervision should I pay for, given that it'll result in me not being able to access physiotherapy.
Roger, do you mind if I add something just on this
Please
section
do.
about the changes? We are talking, and everything that's been said here. I certainly have been involved for the last decade, and I know Roger and Darcy and various number of lawyers have been involved over the years of changes. This is the first time where there's been a change that's been made where the lawyers weren't consulted. I sit on the Ontario Bar Association's insurance group as the chair. We weren't consulted. OTLA wasn't consulted. My understanding, no legal organization or victim rights groups at all were consulted on these changes. This is one of the most dramatic changes that has taken place in the history of accident benefits, and it's against the most vulnerable people. They're taking $2 million away from quadriplegics and severe brain injured individuals, and they're reducing it down to $1 million. And those people need those monies, and that is one of the most drastic changes, and I cannot believe that this government did so without making any consultation out there. We know in the last round that when we sat there with the government and the insurance industry, the indication was that they wanted to reduce the amount of dollars towards minor injuries in order to ensure that premiums could drop. Everybody understood there had to be an adjustment in the system, and that adjustment was made. And when they made that, they all assured that that was to allow that the most vulnerable individuals, the people with catastrophic injuries, would have the monies available to them. So they made those changes. We've seen return of equities in 2013 for the average insurance company at 17.5%. We've seen shares on these companies rise up, and then they turn around and they hit these people. And I'm just indicating that, Roger, I think it's just absolutely wrong. And I think anybody who understands the implications of this would have thought this would be on the front page of the newspaper, and it's not. Snow tires are. To report to your local MPP and tell them what you think, and tell them how this is going to how it's going to implicate the various people that this is going to affect, and those are the victims. I just wanted to add that, Roger.
Well, thanks, Pat. I think we all agree that I hate to say it, but this government has demonstrated very limited concern about the people who will be hurt by these changes. And it's a very cynical adjustment to the system designed to bring down premiums and win votes. And I'm extremely disappointed in the lack of morality and fairness in this scheme. Pat, one last thing. We know how tough it is to turn around a government once it's made a commitment, particularly in this area where the insurance industry is probably licking its lips over these changes. But is there anything realistically that we can do at this stage?
Absolutely, and never go quietly into the night, even if they say that these changes are going ahead. Contact your local MPP and make them aware of exactly what's going on. Certain MPPs don't understand the changes. They gloss over them, and they fully aren't aware of this issue. And I think it's imperative to everybody to write to their local MPP and voice their concerns over these changes.
One question that's come in is, are the changes retroactive? And I can tell you categorically that they are not. So you can relax about that one thing. Another question that's come in, what impact is this going to have on catastrophically injured people in their rehab before the settlement of a tort claim? Well, it's pretty obvious the rehab is going to come to a crashing halt, and there may be years between running out of these new draconian limits and settling a tort claim that probably is inadequate to cover the person's needs anyway. And the next question that's come in relates to optional benefits. Darcy, would you mind just reviewing quickly for us what the optional benefits are and what we should be trying to communicate to people out there about it, there being some value in these optional benefits over and above the lowest possible premium?
So optional benefits are the option to purchase more than the basic policy, which has now been reduced. It's a very good idea for anyone who knows enough to pay for the optional benefits. I have optional benefits. I encourage other people to have it. The problem with optional benefits is it's not well promoted by the industry, meaning the insurance agents and brokers. It's only, the last I checked, it was a 3% take-up rate, meaning that only 3% of the population was purchasing these optional benefits. So it's extremely uncommon. We don't see a lot of clients who have access to the optional benefits. It is available, it is a good idea, but you have to be a named policyholder, so it doesn't apply to somebody on a bus, or a pedestrian. The people who may have benefit claims if involved in an accident, they have no direct access. If they don't have direct access to their own auto policy, they can never access optional benefits. And if they do have direct access to an auto policy, if they've purchased it before the accident, they can access the optional benefits. It's a good idea. It's uncommon. And similarly with tort policy limits, we've been talking a lot about a common policy having $1 million. Well, the minimum limits are $200,000, and almost nobody is silly enough to have a $200,000 policy. What we need to do is to change the paradigm and have the standard policy being a $2, $3, $4, $5 million policy, because that's another way to access more benefits from your own family protection endorsement, where if you're injured by an at-fault driver with a limited policy, you have the ability to access your own policy. So if you purchase enhanced limits on your own policy, it is one way to protect yourself.
Thanks, Darcy. Well, let's leave this sad topic and move to another topic that's of considerable concern, and that's the changes that the government has proposed, and we understand plans to proceed with in April of next year, the changes to the dispute resolution system. And of course, these are mechanisms that are more than just talk and rules. They are mechanisms that have an impact on how our clients, your patients and clients, are able to access benefits when there are disputes. So, Pat, would you kick this discussion off and give us all an overview of what the changes are going to look like as far as we know at this stage?
So, Roger, firstly, on this part, this started with Justice Cunningham reviewing the system. The government felt that it was important that all party stakeholders were consulted. They had regular meetings at the Ministry of Finance as well as in various offices. And the idea here was, let's try to save some money within the system by taking a look at the procedural aspects and the administrative costs. And so the intent behind these changes were, and in all likely will result in, huge savings inside the whole industry because the procedures are being simplified. It's making it easier so that the treatment dollars flow into the insured person's hands in a timely way so that the treatment is effective. So this was a really great idea and great intent behind the government, and it is going to have considerable cost savings. but we won't know that for some time until these are implemented. So what they've done, and what you're going to see, is Fiscal is going to move into what's called the License Appeal Tribunal. We're going to have a separate and new tribunal that determines issues relating to accident benefits. In addition, they're removing the right to bring any accident benefit matters to court, and so that you will be limited going to what's called the LAT, another acronym that we have to deal with. And essentially, on small files, med rehab under 10,000, those will all be done under a paper review system. And that review will be done in a very timely fashion, so that from the time the application is made until you get a decision, it's about 135 days. And so the idea there was, by making a paper review, consolidating mediation and pre-arb into one settlement meeting, and to have a decision released very quickly. The idea is, if you needed 6 weeks of physio, it's been denied, at least you'll have a determination so that the person can get that treatment. On the claims over 10,000, for instance, you'll be dealing with just various, mostly the non-CAT type claims, not the more significant. You're going to have, again, a really simplified system, which is going to be quick, and you're going to have a one-day hearing where it's more restricted on the reports you can use and what can transpire, and the idea is to get a decision made quickly. On the more significant claims, such as CAT determination, post-104, IRBs, med rehab, I believe, where it's over 25,000, you could have a more extensive full hearing, but again, it'll be done within 180 days. Again, the idea is the treatment dollars flow, procedural costs are lowered, premiums, I guess, come down, and there's cost savings in the system. And I guess the only point I'd add on this system, Roger, is I'm really surprised that they didn't take a hard look to see the cost savings in the system before they went ahead and made that drastic cut that I referred to earlier.
Is it then one of the effects of this new system that accident victims who have tort claims and accident benefit disputes will no longer be able to have them all adjudicated in the same place? In other words, will they now have two separate proceedings, one before this new tribunal over the accident benefits and the other in tort in the courts? Darcy?
Sure. Currently, you have the option of going through the FISCO system when you have an arbitration or a formal dispute after a mediation, or alternatively, the courts. The official regulation, which will now apparently kick in April 1st, 2016, removes the right to go to the court. And that is a big concern for plaintiffs, lawyers, advocates, for victims, because we feel good about having the option to run in front of a judge who's got unfettered rights to do the right thing. And there are rules and the rest of it, but we like having that option to let justice be true, to hold a fair outcome. Unfortunately, the proposal, what's going to be law as of April 1st, 2016, it appears, eliminates the right to go to court in any dispute with an accident benefit file. So commonly we prefer the arbitration process for a number of reasons, but occasionally where there's bad faith claims, where there's conduct that we find controversial, reprehensible, we run to the courts, and we like having that option, and now it appears it's going to be eliminated. So that's the first issue. And the second issue is, as Pat was talking about, they intend to have a short process, and that's a welcome goal. They also did, when FISCO was proposed, the Financial Services Commission included the mandatory right to have a mediation within 60 days. Could be wrong about the time limit, but a short window, and that wasn't not in fact enforced, and therefore we ran to the courts, and that was adjusted, and there are ways now to fail a mediation without having to go through that procedural hurdle. So the intention's very good, but it's largely about implementation, and I have some concerns about how effectively they can implement it.
Well, I guess we'll have to wait and find out and hope for the best. The government's track record on new systems is not an enviable one. May I ask Anne Marie and Wanda, can you tell us whether the insurance industry is already training adjusters in this new system, or is the insurance industry just as in the dark as the rest of us?
I can start with that, and I think the answer is we're not quite sure what's going to happen. We don't really know what this is going to look like. A few problems that we see is typically a lot of my clients would be handling in the current system, fiscal mediations on their own, and they would be settling somewhere upwards of 40 to 50% of the claims at the mediation stage before they even needed to hire defense counsel. And with the advent of mediations now being gone and combining it in this new system, my guess is that there's going to be more defense counsel retained on more claims, and unfortunately, up goes the costs again. Another issue as well is there really is no mechanism in place for dealing with the situation of getting these decisions out quickly by the arbitrators. And just following up on what Darcy had said, the FISCO mandate was to have decisions out quickly, and unfortunately that isn't the reality. In fact, I've waited in some cases up to 2 years to get a decision from a FISCO arbitrator. And so I think it's across the board from plaintiffs counsel, and the insurers, we all want quick resolutions to these claims, especially when we're dealing with compound interest rates on cases. So unfortunately, while the LAT system is supposed to be a quicker system, there really is no mechanism in place if the decision makers aren't doing the decisions in the time frames that are being allocated.
And I'll elaborate on that. As the insurers, Roger, I think somewhat we are very much in the dark at. I know within our company we have not yet started in-house training. It's interesting. I was just speaking at the defense lawyers seminar last Friday to a couple of our defense lawyers, Mr. Grossman and Katie, and I was discussing with them about coming in to do some in-house training with us. One of our concerns is for us and also our defense counsel is the quick turnaround time. I think we're going to have to internally adapt and change some of our processes so that we are getting our files to defense counsel much sooner than we are, which in my case, the catastrophic, especially the old ones, are not uploaded on a system, and there's drawers and drawers of paper files. So how are we going to get them to defense counsel? And the question I'm asking our defense counsel, how are they going to review the files and get the responses out and meet these timelines? We have concerns all around. And another concern as an insurer I think we have is this new system. What are the qualifications of the people hearing them? What type of backlash is that going to have on us? I'm not sure if any of the others have any comment to that.
I can add a bit there, Wanda. The License Appeal Tribunal, just to give you the context of what they've been dealing with, they deal with different statutes out there and make decisions under the Liquor License Act, impoundment of motor vehicles, the new home warranties. They do 25 statutes. And so, for instance, a year ago, they did about 700 cases. Well, FISCO has 10,000 applications. And if you look, you can actually go online and you'll see the members that are on the LAT at this point. And it does change because these are only 2-year contract terms. They come from some lawyers not practicing in this area. You get some former chief police. You get a wide selection of different individuals out there that have been appointed to these positions. So it'll be interesting to see where things go in light of the tribunal as it exists now and all these accident benefits moving into that system.
Well, Pat, historically, as we've dealt, I know my area of the catastrophic, the cases that went forward with Bill 59 and the determination of catastrophic and all the areas we had problems under the WPI, the whole body impairment, the marked impairments, and the cases that came out like Pastori and whatnot. It'll be interesting to see how these huge determinations are going to be made in the system.
Well, I mean, that's a good point. And I think there's a lot of concern, and I really don't know how it's going to play out. But if you take a look, there's some people that feel the independence of the decision maker and the security might be lacking because now we're dealing with LET members are really part-time. They have 2-year terms as opposed to, let's say, a fiscal arbitrator that would have tenure. They're paid per diem. They're government appointed. So if you don't like an LET person or the decision making, they're gone in 2 years. So there's all those issues out there too that I think a lot of people are kind of concerned with as to how that tribunal will function.
Well, we're having a very upbeat, optimistic panel so far, and we wish we had more good news. One interesting question that has come in is, can we produce a fact sheet that you can take with you to your local MPP to meet with your MPP, or at least to be the foundation of a letter to your MPP. And certainly we will produce a PIAA fact sheet, and I believe we have everybody's email address from, no, perhaps we don't. If you'd like one, will you please email one of us, anybody on this panel, and we'll make sure that you get this information so that you can use it. And you can probably tell that everybody on both sides of the divide here urge you to contact your MPP. I've been around long enough to be pretty cynical about this, and my impression is that it's purely financial. It's just a question of costs, profits, premiums, and votes, and there's very little sensitivity to the impact on people going through the worst crisis in their lives. And somehow we got to get the message across that, particularly with these catastrophic people, who I've always heard were not the problem in the first place. It was all the whiplash claims and the minor soft tissue claims that were the problem. Why take it out on the people who are the most vulnerable in our society and just toss all the impact back onto the public health system, which is already overburdened? So enough of that. We're trying to deal with your questions as we go along. The next question that I've received has to do with a topic that we knew would come up, and that is the other recent change that hit the healthcare providers like a sledgehammer to the forehead, and that was the pronouncement that where healthcare providers are driving to provide care to their clients, they are required to absorb the cost of their transporting themselves from their fees rather than charging mileage. Let me ask Vanessa and Barb if you can just comment on what you've observed, if any, to be the impact on injured people and their care from this very significant change.
What I'm finding, Roger, in talking to treatment providers, that there are treatment providers who still include mileage on their treatment plan, and some insurance companies are paying it while others are not. But they still put it on the treatment plan, and it's either accepted or denied. In talking with them, they did have a concern about the RSWs, but then they did say the RSWs are non-regulated, so even though they're probably around $60 an hour, they do have the room to increase their rates, so they see RSWs increasing their rate in order to cover the mileage that won't be paid.
Vanessa?
Well, another strategy that a lot of our treatment providers are using is that they're actually grouping their clients. So they are, as Roger had indicated, absorbing the mileage into their fees, but they're trying to be economical about it. So if they have a group of clients that are in the Burlington area, they'll schedule one day a week doing that one, and then one day a week doing clients in Toronto. And another one is also that they're only taking clients to close proximity to where they're located, so mileage is not going to be an issue.
Michelle, many of the clients at our firm are in the north, in the hinterlands, widely dispersed. I know it's often hard to find experienced, properly trained providers in very specialized areas. Are you noticing any impact because of that?
Yes, to some degree we have. To expand on what Barb mentioned, there are still some adjusters that are approving mileage, and I have found personally there's a higher frequency of approvals of mileage for those who live in the north or who live in very, very small remote locations. So that is kind, and kudos to the adjusters and the companies who are still allowing those approvals to come through. But I think the other group that needs our thanks and gratitude is the rehab community, because, as you say, this was a blow. Certainly it's affected the economics in the industry. And I have found on the whole, after the initial wave of anger that we felt from the rehab community, we've seen strategizing, problem-solving, creativity, such as prorating travel and finding other ways to still get the job done. I think there's been an increased conversation in the community around the use of Skype, telephone conversations, having clients meet in the middle, so to speak. But at the very worst, we're still seeing rehab providers getting into their car and going to see that person who's catastrophically impaired, who needs the in-home service. So to the community, a huge thank you for absorbing those costs. I can only imagine it's not been an easy thing to do, and certainly not something that was planned for, but it's fantastic for our clients, so thank you.
Wanda, how's Allstate handling this one?
This is hard for me to speak to because I live in my own little world at Allstate in the CAT unit. Myself, Roger, I've handled this differently depending on the case. My existing cases that are in my caseload, I've had a few of the treatment providers call me, and I said my approach is going to be, and this is individual because at my company we have no template how we're to handle files. So what I'm saying is the existing cases in my pending, I'm continuing to pay mileage. But I agree with what the others are saying because, Roger, I've dealt with clients out in your area, and to get the top-notch treatment providers, we're likely going to have some discussion and consensus. And my thoughts are, if this is coming out of the client's limits, he's made aware of it that I don't have to pay it. If he wants me to pay it, if he wants this treatment provider, if his representative, his lawyer's in agreement with it, I don't think I'm going to deny it.
Well, thanks. We'll just encourage our clients to purchase coverage from Allstate going forward. Wanda?
I may add just one more thing to that conversation, if you don't mind. One thing that we are occasionally seeing is denials of mileage when a healthcare provider is transporting our client for rehabilitation purposes. That, in my view, is completely inappropriate. The mileage is restricted, certainly, for a rehabilitation provider to drive to the client's home. But from the moment that the rehab provider picks up the client and is bringing them to a medical doctor's appointment, to a physio clinic, to the YMCA for their aquatherapy, that mileage absolutely should be paid in accordance with the transportation guidelines. So if there's ever any healthcare professionals or clients who are getting pushback from their adjusters that component of mileage is not going to be paid, I would highly suggest that you talk to your representative on it further.
Thanks, Michelle. Anne-Marie, are disputes over mileage actually mature enough to be getting to your level as counsel?
Yes.
Are they?
Yes, unfortunately. Part of the problem is, and Wanda touched on this, is the fact that we're dealing with much reduced limits. And so if my client is paying a mileage expense, which really is something we now know is not covered under the policy, and we are pulling it out of your medical rehabilitation benefits, I can just anticipate what the argument's going to be at some point when the limits were exhausted, which is, well, you paid something you shouldn't have paid, and therefore we should be entitled to the full limits because you were paying over and above the policy. So that is my greatest concern, and certainly I think Wanda's approach was right, which is if you get, consent from plaintiff's counsel, and from the injured party as well that they do wish to have the mileage pulled from their medical rehabilitation limits, but from a legal perspective, it really is paying over and above the policy.
Sorry, just to expand on what Michelle was saying, that the issue with the with the mileage, if it's not described correctly on the OCF 18 with the division for the treating provider taking the client to the medical appointments, that's where we've seen a lot of the issues, is because then if I call the adjuster and explain, the treating provider will have to send in a clarification and then we can get it approved. So I would just encourage when they're doing that to make sure that they're describing it properly on the insurer fax back about what the mileage is. So the adjuster, when they're looking at it, is going to be able to understand what it is.
Can I add to that too? Before they eliminated the treatment providers claiming mileage, kilometers was becoming a hot topic in the industry anyways. Even though the Ministry of Transportation says it's 55 cents a kilometer, I was never seeing on any of my treatment plans anything under 65, and we've seen up to 90 cents a kilometer. So again, even if I were to make a special allowance and approve the kilometers with council's agreement and the client's agreement, I certainly wouldn't be considering 90 cents. We got to keep it within a reasonable amount.
Thanks very much. It occurs to me, and I'm sure Darcy and Pat would make the same comment, there's a head of damage and tort. If you're a health care provider, I'll just say very briefly, called special damages. And these are actual out-of-pocket expenses that people have. And it's amazing how for many, many years, nobody had any special damages because their costs were all paid through the accident benefit system. We now are finding that we have a clerk developing a schedule of special damages in case after case where we have a tort claim. And most of the special damages are the result of undertakings to pay health care providers for their care and their work with our clients out of the tort proceeds. These are legitimate special damage claims, so much of the costs are being transferred from the accident benefit system to the tort side of the system. That's fine where the limits are adequate to pay the tort claim plus these special damages. But once again, to use the vernacular, it's the catastrophically impaired people with the huge economic losses who are going to get screwed by these changes. I want to switch to another topic here because of the questions that are coming in. And that relates to the difficulties that people are occasionally experiencing moving deserving injured people from the MIG into the non-CAT area, and the consequences that will have in terms of delays for the injured person. I'm going to start with Michelle and ask you, Michelle, if you can sort of put that into context for all of us so that we know what we're talking about here.
Sure. Unfortunately, and I'm sure that our viewers would agree, we often will see clients who have suffered a mild brain injury placed into the minor injury guideline at the onset of the claim. And of course, that has significant ramifications on the person's ability to access benefits. A person who is in the MIG is unable to be assessed for attendant care and has no entitlement to attendant care. And what we'll often see is that these injured people may be in the MIG for 6 months, they may be in the MIG for a year. Sometimes it's 2 full years before the insurance company finally comes through with an acceptance and either bringing forward the non-catastrophic or sometimes in rare cases catastrophic limits. What we have at this point is an issue where we're looking into the past. Attendant care has never been assessed. The person may well could have had a $3,000 a month entitlement in the early days if an occupational therapist or an RN had been into the home. Maybe they had more, maybe they had less. But now we're looking into a speculated entitlement to benefit. It's estimated. I have, unfortunately, a number of clients where we have had to put together an estimated claim for attendant care benefits. And the response that we're having back from the adjusters is that there's no economic loss. For an expense to be incurred, the service has to have been received, there has to have been a promise of payment, and there must be an economic loss. For people who have been trapped in the MIG for, in this example, a year, they didn't have the opportunity to hire professionals. Their family members probably weren't able to take time off of work. They were cared for in whatever way was possible. Family and friends come together. A year post-accident, as the legal professionals, we're having to put in the claim and to fight the fight to see that benefit paid. We are able, in some cases, to succeed with putting forward a argument that the expense ought to have been deemed incurred if the insurance company unreasonably or unfairly kept the person within the minor injury limits, despite overwhelming evidence to the contrary. We may be able to argue that perhaps the courts would have viewed this expense to have been deemed incurred and that the benefit should be paid. In some cases it is. In other cases it's a fight that we have to continue to fight forward. But I think what we need to do as a group, and the healthcare professionals as a community can assist with this, is be really proactive in the management of our clients' attendant care claims. During that period that they're trapped in the minor injury limits, if we are aware that our clients are receiving support from family or from friends, we can document that. Tell the adjusters time and again, the person has need, they need to be assessed, please take them out of the limits, here's why. Likewise, the healthcare community, through reporting of any of the providers, can document the fact that the person's receiving the care. How many hours a day are they receiving? It will make the estimated claims down the road that much easier to pursue.
Thanks, Michelle. Let me ask Barb and Vanessa a question. And in introducing this question, I acknowledge that you as a healthcare provider are not always dealing with a firm like one of the PIAA firms that knows what it's doing. And sometimes you're assisting a client. The client is stuck in the MIG, and you can see the funds running out quickly and nothing being done. Vanessa, Barb, or anybody else, what recommendations would you have to healthcare providers as to what they can do to assist the injured person who is stuck in the MIG, and you sense that the client deserves to be out of the MIG where there's access to better care?
Roger, I personally am not involved on the MIG file, but I am very familiar with the retroactive Form 1 attendant care. If we get a file in, one of the very first things I look at, was there ever a Form 1 done? Has attendant care been documented in the occupational therapy report and their progress reports? I then will put an OT in place to go and visit the individual and do a retroactive Form 1. But before he can do that, or she can do that, he does require all the hospital records, your complete medical brief, all the OT records, and he goes through this and he does complete the Form 1 at different time periods, different levels, because your Form 1, it needs to be clear on the seriousness, the objective injuries, and that attendant care was needed for specific periods of time. That's documented very well, and we do submit it to the adjuster for retroactive attendant care payment. Getting them out of the MAG, I would say that by that point in time, you're probably looking at whether or not there's a mild brain injury documented in the records. You're looking at what the medical legal reports are saying. You're looking at again, you're even looking at whether or not this non-CAT or this MAG file is now no longer a non-CAT, but now whether or not you can move it into a catastrophic application. And you can only do that with having all of your medical briefs updated, all the medical documentation that's been done on the individual to help it move forward.
Thanks, Barb. Vanessa?
I have some experience with this, is that the big thing that you have to look at is family doctor CNRs and get those in as soon as possible and see what pre-existing conditions might be there that have been documented. And don't just send off the CNRs. See if the doctor would write a letter explaining what the condition was and how this impacts treatment and what they're able to assess from that. And then the other thing is to look at whether or not there's been psychological issues as a result of the accident and whether those are pre-existing, and speak to the treating people that have been on the file from before the accident and get their opinions on what treatment would be recommended. And that's usually pretty successful with talking to the adjusters with those letters or records, because then they'll see that there's a history from beforehand and it's not coming from our rehab team. It's coming from someone that's been involved in the file from beforehand and sees what the impact is on the client and what this $3,500 would do or not do for the client.
Roger, can I just add a tip that might help in terms of the misclassification? One of the biggest issues we face is we just don't get the medical documentation that supports the non-MIG classification. And what we're specifically looking for, the OCF3, what are the injuries listed in the OCF3 and are they minor in nature or not? The biggest thing that a lot of people forget is the OCF18. That's really the document which pulls you out of the MIG. And oftentimes we have a list of injuries which again support the MIG classification. So the sooner you can get us the documentation that supports your position that your applicant does not fall within the MIG, the sooner your client can be pulled out of the MIG. With respect to the GP records, which I absolutely agree, the more documentation you get to my clients and faster, the earlier a decision can be made. But it's not sufficient that there just simply is a pre-existing condition in some cases. It really does need to impact the person's recovery. As well, a psychological impairment after the accident might not necessarily be sufficient. It needs to be the predominant injury. So at the end of the day, we really do need more information, and the more we can get from you on the OCF3, the OCF18, a letter from the family doctor, the sooner your client can be pulled from the MIG, and hopefully you don't have to apply for mediation and dispute it through the resolution system.
Can I add to that too? As an insurer, I would be somewhat concerned if it's clear, if we got all the medical documentation that Amy's outlining. I'd be very concerned if it's obvious and clear that the person should not be in the MIG, and if they're held in the MIG, when referring to Section 3.8 of the schedule, basically this section allows an arbitrator or a court to determine if a benefit was unreasonably held to deem that this benefit was indeed incurred. So I think from our perspective, I think that Section 3.8 could transpose to this, to the MIG very easily.
I agree. Just to add to that, I'm sympathetic to the insurers on this one because the misclassification almost notoriously starts with a crappy OCF3. It's filled out by somebody who's dealing with physical injuries, and they document physical injuries only. They don't reference the concussion. They don't reference the attendance in the hospital where they told them about you may have a brain injury, you have a mild brain injury, you have a concussion. And that's what kickstarts the classification in the MIG. And these people, the accident victims who complete the OCF1, have the chiro complete the OCF3 or whoever, don't have legal advice. They don't check it themselves. They don't know what to look for. And the insurer puts it into the category. And then when we get consulted months down the line where there's clear brain injury impacts, we look at that OCF3, we shudder and say, oh, this is how it got off the rails. How do we fix it? And then the case is in that category of this is a lawyer-driven make-up case, when it's not. They're coming to us 6 months later because they're continuing to experience problems. So my recommendation would be anyone completing an OCF3 to be comprehensive and make sure that if it's potentially outside the MIG, you reference the things that may make it potentially outside the MIG.
Darcy, I had a file that was I took over, but and I think we've all seen this. It was a file that The individual had a pre-existing injury. This claim came to me. The individual was hit when he was in his wheelchair crossing the street. It was not a huge impact. He was not thrown from his wheelchair. He sustained soft tissue injuries to his limbs. And this file I took over at the 2-year, the lawyer applied for the OCF 19 catastrophic determination, which through all the assessments and a lot of controversy, whatnot, I called the plaintiff lawyer up to discuss with him and advise I was indeed going to accept this impairment as catastrophic, but I was joking with him. I said, really, I should have put him in the MIG because it was soft tissue. So, I mean, sometimes what it appears to be MIG obviously isn't.
May I just say, I think on behalf of everybody here, we all agree that we may joke, Wanda and Anne-Marie, about the evil empire, but the vast majority of people working in the insurance industry are just trying to do the right thing. There are incompetent lawyers and clerks, just as there are some incompetent adjusters, but most people know what they're doing. They're trying to do the right thing, and it's all about communication. Let's leave this topic because we have mentioned the issue of attendant care. Michelle, you talked about the delay in being eligible to apply for attendant care if you're stuck in the MIG. And I know from the discussions we've had amongst the panel preparing for this that there has been some case law lately. One arbitrator, I'm told, in a case called JZ, Jayzee, held that if there was an entitlement to attendant care before the Form 19 was submitted, the payment for attendant care has to include retroactively the period before the Form 19 was submitted. And that would, of course, include a period the client was in the MIG. But I understand there's been some more case law since JZ, and Anne-Marie, perhaps you could just let everybody know what's going on there.
Sure. Under the statutory accident benefits schedule, the provision is actually quite clear that attendant care is not payable prior to the submission of the Form 1. There has been a recent development of some case law, and the JZ case is the latest case, but it has sort of been a well-known principle that in certain circumstances, attendant care could be payable prior to submission of the Form 1 in circumstances where the details and there was information of the service provider, the types of services that were actually received, etc., were provided prior to the Form 1. So that principle has sort of been in place for a while, and now there's been more recent case law which has been, again, agreeing that in certain circumstances, attendant care can be payable prior to submission of the Form 1. I do note in most of those cases, it's in situations where the applicant has sustained serious objective injuries. So from a common sense perspective, it sort of made sense that the individual did require, and in fact did receive the attendant care. There was a recent decision, and it's called the Reichert, R-E-I-C-H-E-R-T, decision with Gore Mutual, and that came out of ADR April 14th. And in that decision, it was a bit of a different fact situation because Gore Mutual was the insurer, and they had actually had some Form 1s done on the file. And in that situation, the applicant himself had not done a Form 1 under Section 25 and until a later date. And once he obtained his Section 25 Form 1, sought to go retroactively and collect attendant care benefits. And the arbitrator essentially, some of the points that he made were that the applicant had a positive obligation to advise the insurer of the circumstances giving rise to his claim. So in other words, it wasn't fair to put this on the insurer 2 years after the accident, that it now needed to go back and reassess and readjust the claim. as well. In this decision, the arbitrator found there was in fact no right to go back in time and collect retroactive payment for the attendant care benefits. But I do caution you, because I think it might be more of a specific fact-based situation in this recent Reichart decision. I do believe the principle still applies that you can potentially, in cases, go back and collect retroactive Form 1 benefits, but again, it's going to be more of a fact-based situation.
Thank you. Just a couple of questions quickly that have come in. One is, has a date for implementation of the new rules been set? I'm not quite sure what you mean by the new rules. The dispute resolution changes are coming in at the beginning of April 2016. We don't know when the changes with respect to benefit levels will be introduced. But given that the government didn't consult anybody before announcing them, we're all pretty fearful that this could come fairly quickly unless there is a widespread outcry about them. Speaking of that outcry, I've had a number of emails come in requesting the fact sheet. Pat's had a wonderful idea that we will implement, and that is that if you go to the PIAA website, we will there have an easy way for you to pull up a list of all the MPPs so that you can find out who your MPP is and how to communicate with that person, and the fact sheet will be there as well so that you're armed with the information that you need in order to make a difference. And we'll try and have that up on our site in the next few days. I want to turn to another area now. We've only got about 10 minutes or so, and that's an area that's been very difficult for everybody trying to deal with attendant care, and that is the area of incurred expense. Particularly, it's a problem when we're dealing with family members who everybody wants to provide the care, when we're dealing with people who are self-employed, when we're dealing with people who don't have a lengthy track record of employment if they're giving up their job. I'd like to ask Darcy or Pat to start off with this and tell us to what extent this is an issue for injured people and their families in your practice today.
Well, my view on it is I've given up on the fight. I've totally conceded the fight. I will not try to establish a dollar-for-dollar income loss, which is now required under the newest definition of incurred, a dollar-for-dollar income loss. I will outsource attendant care, recommend outsourcing attendant care wherever a client's prepared to do it. And any work done by the family, I'll ask them to log it, document it, and it'll be advanced as part of the lawsuit. I just feel that trying to meet the incurred definition in a more traditional way, which is providing proof of economic loss and the missed job and the missed payrolls, except for the obvious circumstance where a person gives up a job that pays more than $72,000 a year to look after their spouse, which may not be in the best interest of anyone. Unless you have that kind of fact pattern, it's just not worth putting the insurer in a position to demand document after document. Temporally, to say, well, did they miss work this month? Did they miss overtime this month? Where are your tax returns? I won't go into that paper fight. It puts the insurers are in too strong a position to say we need more information. So I've just gone to an outsourcing preference.
Pat Brown.
I echo Darcy. We do outsource it now. I really do think it's sad that on some of this very personal level of caring, that you shut out the people who are closest to you to provide that. Those people will provide it no matter what, and we know they will, and they'll continue to do so. And at the end of the day, they're not going to get payment. But what we'll do, and I think Michelle had indicated it, and you as well, Roger, is we're going to keep that special damage list going for the tort claim so that we make sure that it's noted that these services were provided and that they ought to be compensated. But as Darcy says, it's very, very difficult to keep up with the dollar-to-dollar. type of paperwork that they're requiring on these types of cases, and it's much easier if the family will allow it to bring in an outside agency into the home.
Well, I must say that that's our practice too. We now, as soon as we can, have a heart-to-heart with the families. We explain to them the requirements of the regulation and persuade them that as much as they don't want somebody else in their home outside of the family, they're not going to get compensated if they do it themselves, and they're going to have to hire a PSW to do it. And as Darcy said, it may be better off for everybody anyway. What about you, Wanda? What kind of approach are you taking? What's going on out there that the rest of us don't see? Is this still the focus of a lot of the disputes that you're seeing?
Not so sure about disputes, but it's still a hot tamale of a subject, economic loss. And actually, Patrick, I have one with your firm, and we had no issue with the economic loss. It's a recent file. The mom is providing the attendant care. She was a long-haul truck driver, which she shared with her husband. They both drove together large transport trucks. And she has elected to stay home and provide the attendant care to her son. And your office provided us with adequate documentation, and we made a calculation, agreed on an amount, and we're paying close to the Form 1 in economic loss. Is every case that easy? No. It's a struggle. What I'm finding within my office, more of the problem is the person that may have been a professional that is a family member, like a PSW, providing the attendant care. But we're not working in that field at the time of the loss. So that's a criteria I think causing us more problems at this time.
Can I just add to try to bring this full circle that the incurred definition was just a stupid change. It was a change that was made without consideration for what the normal, rational result would be, which is outsourcing, which is potentially a waste, an overspending of money that would be better used if it was paid to the son, the parent, somebody who could stay at home without having to prove the economic loss. So it was a stupid change without proper consideration to consequences, much like the newest round of changes with the reduction in the proposed reductions in the cat limits, without consideration for what it means is that the tort cases will be way bigger, and that we will be going after people's homes or putting threats on people's homes, at-fault drivers, more than ever, and that people better up their policy limits more than ever.
Well, that's a good point. I never thought I'd start thinking about going after the homes and assets of drivers, but when you're acting for somebody who's profoundly impaired and the limits are just not adequate, you have to do what you can. Just before we leave this incurred expense issue, Anne-Marie, anything that you can add to illuminate us?
Well, I think one of the biggest problems was, and why these changes came to be, was because there was a lot of abuse on the attendant care claims for many, many, many years. And part of the problem was payments were being made on attendant care in situations where it probably really was never being provided. There really wasn't much of an opportunity for the insurer to question or to see if the attendant care really was A, needed, and B, properly being received. And so I think these changes were a response to sort of deal with the unfortunate situation where there was a lot of misuse of that provision of the SABs. And like most things, again, unfortunately, what ends up happening is because of the actions of a few small people and abuse on the one side, it unfortunately has ramifications for everybody under the policy. And similarly, again, on the economic loss point of view, the recent February 1st, 2014 changes where the dollar for dollar came into place was, again, because there was too much abuse on the economic loss. my clients were seeing things such as people would claim a $2 parking voucher in order to claim the $6,000 in attendant care. And again, there was abuse. There was indication that we weren't really sure that benefits were being paid out to the proper people and that the benefits were actually being received. So unfortunately, these changes, I think, were really dealing with a situation of abuse, and it is unfortunate, but really the only remedy is really to hire a professional.
This goes right back to OMPP. We didn't have Form 1s in place, and we were basically at that time paying the economic loss of the individual who was providing the attendant care. So it seems like in many ways we've gone a full circle.
Well, that often happens, and I doubt this will be the last word on any of these issues. There's a question that's come in that we'll just answer quickly. Can we comment on the use of the descriptor essential versus reasonable and necessary, which we've seen in the government's announcement? As I read it, that applies only to goods and services that are not specifically delineated. So if an item isn't specifically delineated, what does essential mean? Well, we're not told what that means. I've been around long enough and am cynical enough to anticipate at the end of the day it won't mean anything different than reasonable and necessary. I see Anne-Marie shaking her head beside me here, so at least two of us share that view.
Just to add, though, the press release referenced not only essential, but and agreed to by the insurer, which basically says that not only does it have to be essential, but it has to be pre-approved. And that may change what really is meant by the word essential.
We are virtually out of time. We haven't been able to answer all of the questions that we've received, but we will attempt to get back to you if we possibly can by way of email if you've sent in a question that we haven't touched upon. There are a lot of them, so forgive us if we don't get to them all. Just a reminder that we are going to have a link or a method for you on the PIAA website for you to obtain a fact situation that will describe the changes to the auto insurance system, and that same location on our website will list the MPPs who you should contact to try and have your voice heard before it's too late. So in closing, I will tell you that the next webinar, we do these webinars every 6 months, as you may know, will be on October the 27th, 2015, which is about 6 months from now. And in the meantime, we thank you very much for attending with us, and may our future clients all be better served by sober second thought on the part of our government. We can only hope that some of these draconian changes never see the light of day. So thank you very much for being with us.